You say he's a diabetic. He says he's a diabetic now, even though apparently he told the police. So the police are either lying in a police report, in which case they should be kicked off the force.
Okay.
A Michigan courtroom. A DUI case that should have been open and shut, but buried inside a routine hearing is a question that could unravel everything. Did the defendant lie to a police officer to manipulate his own breathalyzer test? The judge has already seen it all. He's not easily fooled. And from the very first sentence, he lays down a challenge that cuts straight to the bone. If the police report is wrong, then officers lied under oath. If it's right, then the defendant played the system. Either way, someone in this room isn't telling the truth. This is the moment where a courtroom stops being procedural and starts being something much more dangerous. A battle over credibility, science, and whether a man's medical condition was a shield or a weapon.
All right. People against Norbert Pastor, 25T644-584. Good morning, Mr. Clovis. Your appearance?
Clovis, P3-434, I'm the defendant.
Mr. Pastor?
The defendant here. Oh, here it is.
Your name, sir?
Good morning, Norbert Pastor.
Okay, Mr. Bologna?
Anthony Bologna, City Front.
So, you want to argue your motion now?
Sure.
I don't need to hear about the one with, how do I say this? I'm not, I would not have scheduled this for hearing at all if it was still over the motion to withdraw the plea.
It was a motion to withdraw the plea, was denied.
Correct.
It's a motion for reconsideration.
But you filed a motion for reconsideration. I didn't know that you were asking for a Ginther hearing before. You mentioned something about ineffective assistance and
Right.
go ahead. Why don't you proceed?
We would like a Ginther hearing concerning this because on October 7th of last year, Bobbins's being represented by the prior attorney. He had a medical consultation quite in depth, and it does show the diabetes he suffered from. And I guess ultimately is this, they're claiming by hearsay police report that he said he wasn't a diabetic when asked on the road or I don't know where that they allege. Even if that was true, we deny it, but even if it was true, it's a manifest injustice that he pled guilty, that it was artificially high, his blood alcohol level.
Here it is, the defense's entire argument laid out in a single breath. The claim is extraordinary that this man's blood alcohol reading wasn't real. That diabetes, a medical condition affecting millions, can chemically corrupt a breathalyzer and inflate a reading that sends innocent people to jail. Defense attorney Clovis is swinging for something massive. He's not just asking for leniency, he's asking the court to consider that the very science the prosecution rested its case on was fundamentally broken the moment it was applied to his client's body. And he's calling the police report not a fact but hearsay. But the judge isn't buying it yet, because before any of that science matters, one devastating fact still hangs in the air. The defendant allegedly told the officer he was not diabetic, and if that's true, everything else crumbles.
So in other words, if DNA is somebody's convicted of murder, right, and DNA later shows something, well, you know what? It's not a manifest injustice. I understand that that's the.
Do you have a medical record that tells me, a doctor that tells me that he's a diabetic?
Yes, Your Honor.
Does it say in a report, or am I going to be asked to interpret numbers here?
No. That he's a pre-diabetic. And Your Honor, I'm a pre-diabetic and I have to take a shot and 3 pills every day. So I don't know where they come up with the word pre, but they called me that too. I guess after a certain number, you become a diabetic officially. But I take Ozempic and I take 3 other pills for my pre-diabetes.
I know, but a lot of people take Ozempic just because they want to lose weight too.
It ain't losing weight. Mine was almost going into shock when I was in Chicago about 2 years ago.
Well, if this is a report dated October the 7th,
Right.
what is this medication that he's on?
What kind of medication?
Metformin.
For what?
Metformin.
What's that for?
Diabetes. I'm on 1,000 milligrams daily for the last 2 years. We had produced last time the prescription history from Myers.
And then something remarkable happens. The judge, the man sitting behind the bench deciding this case, reveals that he himself is pre-diabetic. He takes shots, he takes pills. He almost went into shock in Chicago. In trying to discredit the defense's argument, he inadvertently humanizes it. The courtroom suddenly feels less like a legal proceeding and more like a conversation between people who actually understand what it means to live with a condition that medicine itself can't agree how to label. Is it pre-diabetes? Is it diabetes? The line is blurrier than any jury instruction could capture. But the judge catches himself. Personal experience is not legal precedent. And the brutal question returns. Why, if this man was diabetic, did he tell the officer otherwise? Was it ignorance? Embarrassment? Or was it something far more calculated?
Have you seen this, Mr. Bologna?
I have not yet.
The pre-diabetes. That doesn't mean he's a diabetic, though, right?
Your Honor, I'm a pre-diabetic and I have to take the shot.
Why would he have told the police officer he wasn't diabetic?
First, it's a police report hearsay. Nobody's testified to that. And the bottom line is, Judge, respectfully, if they're inaccurate results, that's a miscarriage of justice. If they can't do that test.
Well, wait a minute. You mean I could, if I'm diabetic, I could tell them I'm not diabetic, have them lure them into giving me an intoxilizer, and then come back and argue that the intoxilizer results are invalid because you bought my lie and you relied on it and you didn't get a blood draw instead?
Judge, I doubt very much that he knew scientifically that he can't take the breathalyzer. His attorney didn't know, and it was never brought up though.
Because why would a lawyer bring it up when their client told the officer they weren't diabetic?
The judge just painted a picture that's impossible to unsee. A man walks up to a police officer, looks him in the eye, and says, "I'm not diabetic." He blows into the machine. The reading comes back high. He gets charged, he pleads guilty. And then, months later, he comes back to court and says, "Wait, I was diabetic all along and the test was wrong." If that sequence of events is accurate, it is arguably one of the most audacious legal maneuvers a defendant could attempt. Use your own deception as a defense. Make the officers trust in you become the very weapon that defeats the case. The judge isn't just frustrated, he's borderline incredulous. Because this isn't a loophole. This would be a blueprint. And every judge in America knows that if this argument succeeds, the consequences extend far beyond one courtroom in Michigan.
Your Honor, that's hearsay right now.
All right.
You're relying 100% that the officer said that.
Well, who are you relying on? You're handing me a police report you're handing me a medical report that says pre-diabetic. You say he's a diabetic, he says he's a diabetic now, even though apparently he told the police. So the police are either lying in a police report, in which case they should be kicked off the force.
Okay.
Who's saying he's a diabetic? This says pre-diabetes. What information do you have to tell me that the lawyer should have pursued that?
Pre-diabetic is like diabetic. That's what I am.
Well, you're saying that. I don't know that to be true.
Making it up.
Well, I don't know if you are or not.
Oh, there you go. Okay.
Well, you guys are coming in now saying there's diabetes involved, and I don't have any evidence of that.
You got it in front of you right now.
It says pre-diabetic. What do you have to say, Mr. Bologna?
Your Honor, if the request is for a Ginther hearing this point, it's focused on ineffective assistance of counsel. All we have to work off is what we have in the report and what was done up until now. The report says that he stated he was not diabetic. So the question is, was there ineffective assistance of counsel? The counsel is reviewing that report. I can only assume that he's not going to ask me follow-up questions as it relates to diabetes. So unless there's something that states where the client presented prior counsel with a statement saying I'm diabetic or medical records to prior counsel stating that he's diabetic, I think it's safe to assume that there was effective assistance of counsel in this whole process.
Now the prosecutor steps in, and his logic is cold, precise, and almost surgical. If the police report says the defendant denied being diabetic, then the defense attorney had no reason to investigate diabetes. A lawyer is not a mind reader. A lawyer works with what the client gives them. And if the client gave the officer a lie, that lie traveled all the way into the defense strategy and poisoned it. This is the essence of the ineffective assistance of counsel argument imploding in real time. For the defense to win, they'd need to prove that the attorney failed to do something. But what do you fail to do when the only evidence you have points away from what you'd need to investigate? The legal standard here is razor thin, and the prosecution knows it. They're not arguing the defendant is guilty. They're arguing the defense lawyer did exactly what any reasonable attorney would have done, given what they were told.
Prior counsel didn't even know what diabetes does, or pre-diabetes.
Who said that?
Hearing, I'll have a doctor sitting up there during the Gunther hearing and the former attorney. The results are just, they're void. We can't say, well, you said something to the officer, so we're gonna put everything aside.
Okay, so I just want to ask you this question. If the officer comes in here and tells me, Judge, unequivocally, the defendant told me he was not diabetic, how, and if I believe that officer's testimony, you still think it's ineffective assistance of counsel because the defense lawyer didn't pursue an avenue when the officer had been told by the defendant, according to the officer, that he was not diabetic, and therefore that the defense simply could lure somebody in by saying, no, I'm not diabetic, wink, wink, and then go back and say, I was diabetic and the results are skewed. I can't even imagine a lawyer trying to argue that his client's diabetic if the officer was told by the defendant, if the officer was told by that, you're right, there are mistakes, that he was not diabetic.
He's got medication with it. And it's on the report, his medication.
Which report? The medical report or the police report?
I believe both. I'm getting.
I didn't ask you that. What report are you referring to? The medical?
That report
The
has,
medical report.
and I'm sure the inventory, and I don't have the inventory report, has what was on it. I don't have an inventory report. I don't,
What else? Anybody else want to help me out here and tell me why I'm thinking incorrectly?
The defense just dropped something quietly devastating. The medication was reportedly listed on the police report itself. If that's true, if an officer documented the defendant's diabetes medication during the arrest and still administered a breathalyzer, then the entire dynamic of this case shifts. Because now it's not just about what the defendant said, it's about what the officer may have seen and chosen to ignore. But the judge won't let it slide that easily. He wants to know which report. He's not going to let a vague gesture toward the report become the foundation of a legal argument. Precision matters here. Evidence matters. And right now, the defense is working with fragments. Notice the judge's last line. Anybody else want to help me out here and tell me why I'm thinking incorrectly? That's not genuine openness. That's a judge signaling he's already leaning hard and daring someone to change his mind.
Mr. Bologna, Mr. Colovis?
a hearing would resolve, so it'd be a very short hearing.
You're going to bring in the doctor.
I'll bring in his treating physician, how to make up one, and how long he's been on it. So what I'm saying is, let's just say that the officer heard that my client was not a diabetic. Let's just say, does that mean that test results go in? Absolutely not. You got to lay foundation. And one of the foundations is, if you're diabetic and you blow.
If you're conceding that he told the officer he was not diabetic, are you conceding that?
No, I'm saying what, the worst case scenario. I haven't seen a video. I haven't seen it.
I can't imagine me or any other judge throwing out a case on the basis that they should have administered a blood draw as opposed to a breathalyzer if the officer was told, and the court believes that it's truthful testimony, that the defendant told the officer he's not diabetic. I can't imagine me throwing out a case saying, it's a miscarriage of justice. He should have been a mind reader. He should have been Houdini. He should have been a read everything.
Nobody says throw it out. What we're saying is those results, if all true, the breathalyzer results are excluded. And now they can try their case the old-fashioned way.
And there it is, the actual ask. The defense isn't demanding a full dismissal. They're asking for something more surgical and arguably more dangerous to the prosecution. Throw out the breathalyzer results entirely and let the state rebuild its case from scratch without its most powerful piece of evidence. This is a classic litigation pivot. When you can't win outright, you strip the other side of their weapons and force them into a fair fight. No machine, no number, just an officer's testimony and whatever else was observed that night. And suddenly, a case that felt airtight starts to look very different. The judge understands exactly what's happening. He's not confused, he's calculating. Because if he grants this hearing and the doctor's testimony is compelling, he may have no choice but to act. And that's a precedent with consequences that reach far beyond this one courtroom.
Well, that's what I meant, throw out the results.
Correct. You know, that's like not watching a person for 15 minutes, they regurgitate and then they blow.
No, that's a lot different than somebody telling an officer, I'm not diabetic, and for the officer, well, I'm gonna pretend you are. I'm gonna pretend everybody's diabetic because they could be lying to me. They could be luring me in. I'll give you your hearing, but I hope you're not wasting the court's time.
I will.
You subpoena the officer, Mr. Bologna. I know you said at one point he doesn't work for the department. I want that officer here. And I want to hear testimony. But I can tell you, honestly, Mr. Kolovis, I can't imagine any judge worth 13 cents throwing out a breathalyzer because they administered a breathalyzer to a diabetic who happened to tell them that they weren't diabetic.
So the breathalyzer was not working properly.
Did you hear what I said?
You leave the results in.
If I administered a breathalyzer because the defendant told me he was not diabetic, yes, I would.
He also told him he wasn't drunk. It was for that.
Come on. I'm not going to argue about it with you. I'm just telling you. I have a feeling there's more to this, but I'll listen to it. We'll have a hearing.
You also told him he wasn't drunk. 5 words. And the defense attorney's argument momentarily stops breathing, because the judge just made a point that cuts deeper than any legal citation could. If we're going to say the defendant's self-report about diabetes shouldn't be trusted, then why should any self-report matter? The defendant also denied being intoxicated. Should officers have believed that too? But then, almost reluctantly, the judge exhales. I have a feeling there's more to this. That single sentence is everything. It means he's not fully convinced the defense is wrong. It means there's something in this case that hasn't surfaced yet. A detail, a document, a testimony that might reframe everything. The hearing is granted, and in courtrooms, a granted hearing isn't a victory. It's an invitation to a fight where the rules are set by a judge who's already told you exactly how skeptical he is.
When are we going to do the hearing? I want to do this quickly.
Yes.
How do you want to do it? 2 weeks, Judge, or how?
Yes. May 7th.
May 7th. You want to do 11 o'clock?
Can we do it later in the morning? Because I'm in Ann Arbor again. That's where I was this morning. I had to drive right back there.
All right, let's do May 7th. Yeah, 11 o'clock?
Can we?
You're going to subpoena?
May 2nd to May 10th, the family is on vacation.
To where?
For what? Why don't you tell report?
They're going down to Florida for conference.
I can't hear you.
I'm sorry. I needed to request a time between May 2nd and the May 10th. I tried to voice.
You got to keep your voice up.
I'm sorry, sir. I needed to request time for the May 2nd to the May 10th.
There's a medical conference.
I go and meet like 2 of my doctors in Florida. I'm sorry about that.
That's.
You want to do it before then?
You going to be able to get somebody here before then, Mr. Bologna?
I have no clue on the officer's availability here, so I'll try my best.
What days?
Why don't you go call him real quick? See if you can get a hold of him.
I'll see.
Because I don't want to put this off to the 21st. I really don't. Can you,
Thinking next Thursday?
if everybody's available, that's exactly what I'm thinking.
Your Honor, too.
That's April 30th, right?
Yes. Being that this is a Ginther hearing, though, the hearing is to determine ineffective assistance of counsel.
Okay.
Concern is we're going to get into the weeds and create some type of record now as it relates to evidence that wasn't even put forth before this court in consideration of how we got here.
That's the effective assistance of counsel.
Well, my view is should be more focused on, did counsel even know about this diabetes? Is there any evidence that counsel was aware of this?
Well, of course, that's all part of it.
I guess we'll find out.
They have to prove, essentially, that the defendant is diabetic. It was conveyed to defense counsel. Defense counsel didn't pursue any kind of defense, period. That's generally speaking, but that's what they're going to have to prove. I think your point in your brief is well taken. Why I'm so frustrated is because I just can't imagine somebody, a lawyer, reading in a police report that his client admitted that he was not diabetic, or at least told the police he was not diabetic, and then faulting the lawyer for not pursuing a claim that the intoxilizer or breathalyzer shouldn't have been administered because he's a diabetic.
The judge just issued the clearest possible roadmap for how the defense must structure their case. 3 things must be proven, and all 3 must connect like links in a chain. First, the defendant must be shown to be diabetic, not merely pre-diabetic. Second, that diagnosis must have been communicated to the defense attorney before the plea. And third, the attorney must have failed to act on it in a way no competent lawyer would fail to act. Break any link in that chain, and the entire argument collapses. This is why the judge keeps circling back to the police report. Because if the defendant told the officer he wasn't diabetic, it's nearly impossible to argue that the attorney should have known otherwise. The client is the first line of disclosure in any attorney-client relationship. What happens at this hearing will determine whether a guilty plea stands or whether an entire DUI conviction gets rebuilt from zero. And somewhere in Michigan, a police officer who may or may not have documented everything correctly is about to be summoned to testify. The courtroom is ready, the clock is ticking. And the truth, whatever it is about to be forced into the light.
I can't imagine somebody lying to the police about whether or not they're a diabetic. And even if he wanted to come in and claim that he was diabetic, if the officer's testimony is to be believed, let me be clear about this, how am I going to find that there's ineffective assistance of counsel? That being said, let's figure out what day we're going to do it. I will honor your client's ability to leave the state between May the 2nd and May the 10th.
How about 4/29 as well? Next Thursday.
I'll tell you what, I'll make it. Am I good that time, Heather?
On which date, Judge?
April 29th at 11.
Let me look at our docket.
Is that the 29th?
It's a Wednesday.
That's a
Oh,
That's
Wednesday.
a Wednesday.
Let me just check something. The 20.
30th is what I thought.
Yeah. Are you good at 11 on that day?
But, yeah,
Well, you're here with Judge Hessen, though.
I'll be here.
Why don't we do it?
We can
You
it.
do have a trial at 11 on the 30th,
What kind?
a domestic violence.
Let's do it at 1 on the 30th.
That'd be perfect.
Now, here's the thing, though. If either one of you can't get your officer here, can't get the doctor here, then we're going to have to adjourn it. So you guys can be big boys and figure out a time with my judicial clerk, okay?
That's great.
April 30th at 1, okay?
Thanks, sir.
Thank you.
April 30th, 1 p.m. A date circled on a calendar that could change everything for Norbert Pastor. The judge has agreed to hear it, but he's made his skepticism unmistakably clear. A doctor will take the stand. A police officer will be subpoenaed, and the former defense attorney may find himself sitting in a witness chair defending decisions he made based on a police report that said his client wasn't diabetic. This is what legal battles actually look like, not the dramatic objections of television, but the grinding, precise, exhausting process of proving something happened differently than the record says it did. Every word spoken in this hearing will matter. Every document, every prescription bottle, every timestamped medical note will either build the case or bury it. And at the center of it all is a single unanswered question that this judge still can't shake. Why would anyone lie about being diabetic during a DUI stop? The answer to that question may be the most important thing said in that courtroom on April 30th, because depending on what it is, it either sets a man free or confirms that justice was already served. Thanks for watching video, like and subscribe for more videos.